Hello, and thank you for joining me for another episode of You Would Think. Today, we find ourselves back in the courtroom with the Alex Murdaugh pre-trial motions hearing. For our newer viewers, a little background. Alex Murdaugh was a prominent South Carolina legal dynasty. His wife Maggie and son Paul were murdered on his property in 2021. He had repeatedly told anyone that would listen that he had never been down to the kennels on his property where this crime occurred. But through his deceased son Paul's Snapchat video, if you'll recall, there was a video that he had taken moments before it's believed that they were killed, and you can hear Alex Murdaugh's voice on that recording, kind of blowing apart his not being down by the kennel. He was also convicted in a separate trial for massive financial fraud done through his personal injury practice, embezzling millions over the years. He was convicted in 2023, though his murder conviction was later overturned when it was learned that the clerk of court at the time, Becky Hill, was insinuating some things she shouldn't have been insinuating to the jury. Because of that, the Murdaugh was eventually granted a retrial. Full disclosure, I am not an attorney. I do not have a law degree. My degree is in crime scene and forensics and crime scene technology. This is a trial channel where we can discuss trials and engage in them. I like to, hear things from all of your perspectives, and watching trials and true crime cases had just kind of been a bit of a hobby of mine. So I thought, let's make a YouTube channel so I can share it with you. Let's jump into it. So we are back in court, like I said, regarding the Alex Murdaugh retrial. Murdaugh was granted a new trial after it surfaced that the clerk of court, Becky Hill, in the original trial was trying to influence the jury to lean a little more toward the guilty side, inevitably so that she could sell more of a book that she had written on the case while on the case. So now all the gang's back together. We have for the defense Mr. Dick Harpootlian and Mr. Griffin, and for the prosecution is Creighton Waters. So today's hearing was the day that the new judge, who I really like so far, you'll see why, heard a slew of pretrial motions ahead of the retrial that at the moment is scheduled for April 5th, 2027. Some pretty big decisions were made that are really going to kind of shape how this trial is going to proceed and how it is going to look like a much different trial than the original trial back in 2023. So we'll address these motions that were filed and argued by the attorneys, as well as the judge's rulings on some of the motions. So first up, we have for the defense, Mr. Harpootlian asked if some of his experts may possibly be able to testify through FaceTime. And the judge said that we will pretty much cross that bridge when we get there, should we get there. Next was the defense's motion regarding discovery issues. The defense alleges some secret agreement with Mr. Eddie Smith, who you'll remember was the defendant's distant cousin who was involved in that roadside shooting, stating the prosecution has an obligation to disclose if there is a deal. They have an obligation to disclose that information. They also allege that there are some police credibility issues. God, not those. And he cites that one of the SLED agents that were involved in the original trial was accused of withholding exculpatory evidence, which is just evidence that could, go to prove a defendant is innocent. And defense wants to know if he was reprimanded, and he wants to look at their HR paperwork so they can see if that agent, as well as a few other officers that have been terminated since Murdaugh's first trial, to see if it had anything to do with dishonesty. And then they made an allegation which has not been proven in any way, shape, or form. I didn't even really want to mention it in this video, but in the spirit of full transparency, they allege that the missing assault rifle used in the 2021 killing of Maggie Murdaugh had recently been used in an Allendale County murder, and they're requesting information on that. They allege the state is not taking their responsibility and obligations seriously. To which the state responds with that there's no agreement with Mr. Smith. He says there's no evidence of any of the officers who were terminated were do so for dishonesty. And they continued and stated any tips that they receive will be provided to the defense in a speedy manner, and that this is the first time he has heard about the murder weapon being used in another crime. Well, let's take a little short look at his argument.
There's ongoing obligation by the state. They say that
there's an ongoing obligation by both of y'all.
And so there's some items that we would have expected to receive by now, and we have not.
Let me know what those are. What are they?
So, as Your Honor well knows, the state has to produce evidence, information pertaining to, that the defense could use to challenge the credibility or truthfulness of a witness. It's called Giglio material, and it's in the United States Supreme Court, Giglio v. United States, and these include plea deals and promises, even secret agreements, evidence of witness bias, and credibility issues of police where there's evidence of past misconduct. And in that category, I have a few items as to secret agreements. There's a co-defendant in some cases, and then he's been charged separately. His name is Eddie Smith. Curtis Eddie Smith, who's a distant cousin of Mr. Murdaugh, was charged on November 2021, almost 5 years ago, of abhand, pointing and presenting, conspiracy, filing a false police report, and that's related to a roadside shooting that involved Mr. Murdaugh. Subsequently, in June of 2022, he was indicted by the state grand jury of 4 counts of money laundering, trafficking in meth, of other things. 4+ years have gone by, and those cases have not been disposed of. Every other case that we're aware of have been disposed of. And it begs the question, why not? Do they have a cooperation agreement with Mr. Smith? If so, what are those terms? He has been identified as a witness in this case since the last trial, well before the last trial. So we've got nothing on Mr. Smith. And if they have a deal, they're obligated to disclose it. If they have an understanding, they're obligated to disclose it, and we've never received it. With regard to credibility issues of police, we are aware that Judge Roger Young dismissed a murder case, and the name of that case is State v. Michael Colucci, and he was indicted in 2015. In June of 2025, Colucci's attorneys filed a motion to dismiss the indictment, saying that the state withheld critical exculpatory evidence on the eve of jury selection. We don't have subpoena power unless we subpoena them to a hearing. They have control and can request this. We don't have it, and we would like it. And so, Your Honor, that's some Giglio material, some Brady material that we have, think we're entitled to. And as you know, Your Honor, Brady is evidence that is, could be exculpatory. We have learned through reporting from Fitz News that there was a recent murder, we believe, in Allendale County. And what has come out of that investigation and what has been leaked to the press is that Murdaugh murder weapons were connected to the Allendale County murder. Now, how could that be? And so we would like to know, were Murdaugh murder weapons connected to this Allendale murder? Now, if Your Honor will get into this, you'll learn that the SLED agent ballistic forensic lab did an analysis of just the shell casings on the 300 blackout that was used to murder Maggie Murdaugh. And the ballistics expert testified that the extraction marks on those shell casings found at the murder scene matched extraction marks found on shell casings around the Moselle home and at a shooting range. And their analysis was, in his opinion, it was the same gun that injected the shell casings of the 300 blackout at the house, at the driving range, and at the murder scene. Which leads us to, we don't know if it was the same murder weapon in Allendale, but if they did an analysis of the shell casings in the Allendale murder case, and they're saying it matches the shell casings for the Murdaugh murders, either their test is bad or someone's out there using a gun to murder other people. And so we would like that information. And then there's generally, we are aware that SLED has received tips, because we've received tips. We've not been provided any information about tips of whether it's reliable or not, identifying anyone else other than Alec Murdaugh participating in the murders. We've not received any information. Have they found the murder weapons? Have they found the murder weapons since the last trial? And there's related information underlying all of those. And so we don't think the state is taking their obligations seriously enough.
Mr. Waters, let me hear from you on the Giglio.
Yes, ma'am. First of all, I want to say we take our obligations very seriously.
I know you do.
And have never had a problem. This is the first they've raised these specific issues. They could have given me a call, and if I ever discovered anything of importance, they're the first people that I call, and that's always been our practice. As to Giglio, as to Eddie Smith, there is no cooperation agreement. I don't have any secret agreements. If I had any agreement with the individual, I would disclose that to him. They have all the witness statements. They have the state grand jury testimony. They've had every bit of information that we have on, and every bit of discovery that we have on Eddie Smith. And there are no secret agreements. And if I do ever engage in agreement with any witness, I will disclose that immediately to the defense. I understand that obligation very well.
Right.
As to
And those cases are still pending.
That's correct. Yes, sir. Yes, ma'am, Your Honor. Inquiries I've made, and my understanding is that none of that had anything to do with dishonesty or falsification of reports or anything that would go to Giglio, that they were personnel matters. I will, of course, re-verify that, and if there's anything that needs to be provided in that regard, I will, of course, provide that to the defense. But that is my understanding at this time. And again, we always renew our Giglio inquiries for any law enforcement witness that testifies as we move to trial. And obviously, if anything's forthcoming, we'll provide that. But those issues are not there. As to tips, we provided a lot of that information before. But as I said, this case was tried, over 3.5 years ago. And so we are in the process of, correlating. Heck, I get emails from all over the world to this day, but we characterize or categorize those, and there will be any sort of information, no matter how fanciful and far-fetched, and that'll be provided to the defense as well. And so again, that, as you recognize and as we recognize, that obligation is ongoing. We take it seriously, and anything that has developed since that time, we will make sure to provide to that defense. We are constantly always doing discovery audits and discovery checks.
All right, well, tell me about the Allendale with
I'm sorry, Your Honor.
the murder weapons.
That's the first I've heard of that. I have never heard the first thing about that. If somebody told me that they had matched that to the murder weapon, not only the first call again I would be making would be to them, and the second call I'd be making would be to Your Honor. That is the first I've heard of that. I've never read the Fitz article. Certainly nobody at SLED, who I communicate with on a daily basis, has said, hey, Creighton, by the way, X happened. So I will certainly look into that, but I would be flabbergasted to find out that actually had happened and no one had advised this office of that.
Okay. All right. I hope that answers your questions. He's going to get back with you.
All right, next. In another defense's motion, they're requesting to amend the questionnaire that would be sent out, to potential jurors within that county where Murdaugh would be tried for his retrial. They say they believe that Becky Hill influenced who got on the jury as well. So they want jury selection overseen by the judge. And we can watch the argument on that.
Huge questions, obviously, after we learned of the court's conduct about how certain people maybe got on the Venire and others did not. She was apparently excusing people. I'm not saying expecting that to happen again.
Again, this is the first that I've heard of any issues with that. I mean, my understanding is with Judge Newman's supervision, obviously a number of ones that were excused based on patent exemptions, such as over 65 who claimed that were non-residency issues and that sort of thing.
Right. Would be my understanding of what normally happens
And when we
pick a jury here.
We had the whole panel arrive. Yes, there was something like that. Obviously, she was excused. There were also people that had close relationships with with Alec Murdaugh and the Murdaugh family. And of course, we vetted all of that and excused as appropriate.
Well, but what was never done, and I tried to get the list, compare the initial list that was generated in Columbia to what actually were summons that were issued. And certainly there were people that the clerk said,
They don't live here. They're over
Right.
65.
dead, whatever. I get that. But if we never got the original list, so we don't know. And again, call me suspicious, but when we have evidence that the clerk of court is attempting to influence the jury to obtain a guilty verdict so she could sell more books, when did that start? Did it start when she started winnowing down people she thought might be helpful to us? And I'm not saying that could happen again, but I think I need to say to the court, I never expected it to happen the first time. I've been doing this 50 years. I've never seen a clerk of court interfere in this process. And clearly our Supreme Court found she did.
Okay. Well, I can tell you, Mr. Harpillion, I certainly don't mind overseeing it.
Thank you.
So the judge saying she has absolutely no problem with that, and we are moving right along. Next is a state's motion to exclude results of the prior polygraph examinations. They argue the polygraph is just a tool and it is not reliable, which is a well-known fact. I kind of think the defense was just fishing with this one. The defense is asking the judge not to exclude the use of the polygraph because they may want to use it if Eddie Smith is called to the stand. Since apparently back in 2023, when asked, "Did you murder Maggie and Paul Murdaugh?" he failed. And when the same question was asked of Murdaugh, he apparently passed. They alleged again that Eddie Smith had some kind of deal with the prosecution, and that deal was withdrawn once he failed the polygraph. State reiterates, no, there was never any deal with Eddie Smith, and they again state that the Supreme Court said polygraphs are not reliable. So this ruling, may not really come as much of a surprise, but the judge ruled the polygraph is not reliable, and any mention of a polygraph or the polygraph results in front of the jury could cause a mistrial, to which the defense, Dick Harpootlian, joked and said that she should start by sanctioning them if they mention it before moving right to a mistrial. So let's check out that lighthearted exchange.
Good order prohibiting the mention of polygraph, although I will concede I would not do that without having free trial, the in-camera hearing of some sort and getting clearance from you.
Well, that's going to be my ruling, Mr. Harpootlian. I'm going to rule that the results of a polygraph examination are not admissible, as well as the defendant's willingness or refusal to submit to a polygraph. And I'm going to tell you now, there is to be no mention of a polygraph test before the jury. This ruling is based on counsel and case and the Palmer case. Should the defense seek to introduce any evidence or testimony or reference concerning a polygraph examination, you must notify the court and obtain a ruling outside of the presence of the jury, or risk this case being a mistrial. You understand?
Well, I think, Your Honor, you probably shouldn't threaten mistrial. You should start contempt.
Contempt. Yeah, you don't want me to hold you in contempt, Mr.
Well, I don't want you to
Harpootlian.
mistry the case.
And I might mistry it if you start screaming polygraph. So without letting me know beforehand. You understand? I want to make sure everybody's on the same page.
I got it. I think I suggested it. I agree with you.
Okay.
Next, we have a state's motion to admit previous testimony from the first trial and use it in the retrial. This was one of the biggest, if not the biggest, motion that was filed that had a lot writing on it, really. So, the state, they want to admit previous testimony from the first trial and use it in the retrial. This mostly revolves around the kennel video and the big lie, which was that he had never been down at the kennels, and other statements that were made to family and friends, including Alex's own statements, because he chose to take the stand. You'll remember that disaster. He also wants to use it for impeachment purposes. The defense cited the statute that states you cannot use prior statements in a new trial, and the state argues this is not a new trial. it is a retrial that will feature the same evidence and the same testimony and all of the same hallmarks of the first trial. And that seems to be like the biggest distinction for this specific motion. Is it a new trial or is it another trial? Defense counters with stating multiple times that the state said, in his own words, that this was a new trial. But the prosecutor shot back with that he's taking his words out of context. The ruling that the judge decided to go with is that yes, prior testimony is allowed because this is essentially the same case. Like I said, this was a huge win for the prosecution. And on the same token, a devastating blow to the defense. But as the judge explains in her ruling, when you take the stand, you not only take a risk of being exposed to cross-examination, but now you've got sworn statements that are on the record. And you never know when or how those might be used. Next motion was a state's motion compelling the defense to turn over the defendant's cell phone data and wants to bypass the privileged information stating that the defense always got the unredacted version of all of the data while the state always got the redacted version. There was no objection. And the second part of that was that the state wants the information, once they retain it, authenticated. Again, there was no objection. So the judge granted this motion, but did say that the defense has to give the state adequate notice of what information from the phone they plan to use and gave them a deadline of March 1st. 2027. Next, we have another state's motion regarding DNA. And they claim they want to be able to test the fingernail clippings and some more of the biological DNA that the defense is currently in custody of. The defense, however, stated that in the original investigation, during the DNA testing of certain items, those items were destroyed, mainly a t-shirt, and therefore no further testing could be done. And they are afraid of the same thing happening with this little bit of DNA that they have left.
The last case, they indicated there was blood spatter on a t-shirt. We wanted to examine it. We wanted to have it tested. SLED violated every rule known to man and destroyed the t-shirt in the process of processing. Now,
they say if the state wants to test it, that's fine. But they want it tested by an accredited source. So in other words, we don't trust SLED. They want it through a specific company because they know that it's kind of like the gold standard, supposedly. And it's the same company that tested the DNA in the Idaho murders with Brian Kohberger. The judge ruled that the defense can test what they want and was instructed to then give the leftovers to the state for testing. Okay. I'm not sure how much, water that holds because I'm not an attorney. And lastly, a defense's motion for a change of venue. This was the other huge motion that had a lot riding on it. The defense claims that due to the extensive media coverage and the tainted jury pool from the first trial, that they would like to move the trial out of Colleton County. The state argues that that would be too expensive. So what does the defense do? The defense calls one of their own attorneys, puts him on the stand, asks questions about lodging and things like that. I guess this attorney happens to live in like a neighboring county. And he was basically testifying to the fact that it really wouldn't be as expensive as the state claims. So now let's watch and listen to her ruling on a change of venue.
Prejudice arising from the size of the county and the long-standing association between the defendant's family and the 14th Circuit. Third, the South Carolina Supreme Court's determination that the former Colleton County Clerk of Court improperly influenced the jury, depriving the defendant of his constitutional right to an impartial jury. And fourth, the form of publicity surrounding this case. There's case law that says I can't transfer something just for publicity. That can be cured. But with the four grounds that I've just stated, I am transferring it. Further, this ruling is supported by the court's recent order in a village to get this case transferred. For those of you who don't know, there's a lot of other things besides walking into a courthouse and sitting down and trying to try a case. We have to consider security, transportation. Is a courthouse adequate? Is there lodging? There's also docket considerations that have already been set for next year. There's a bunch of matters to consider. So what I'm going to do is I will think about it. I need to look at it. I will tell you, Mr. Waters, you are correct. Cost is a concern because Colleton County does bear the cost of the retrial in this case. Colleton County is not a rich county. It's a poor county. So that will be at the foremost of my thoughts when I transfer this case. I was in hopes that the two of y'all could agree on a destination, but since that's not happening, I will decide and I will let y'all know.
And there we have it. She said that she is going to reserve her ruling for which county, and she explains. But it won't be in Colleton County. So we'll have to watch how that unfolds. And another side item was a motion from one of the previous jurors' attorney who wanted to keep the protective order in place, but the judge ruled that she's unsealing it, and if these jurors, like some already have, want to go do interviews with, ABC and TMZ and whoever, then that's at their own peril. She's also reserving her ruling as it relates to the financial crimes and how much of the financial crimes will be able to come into the retrial instead of, in my opinion, way too much in the first trial. It's like, yeah, the guy's a scumbag, but does that make him a murderer? He wasn't on trial at that point for the financial crimes. He was on trial for murder. So that is a quick synopsis of our first hearing that kind of marks, the get up and go of the Alec Murdaugh retrial. And thank you all very much for joining me, and I will see you next time. Have a great night.